Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer. And today's video is the second video in our series regarding WUCIOA, the new Washington law that took effect on July 1st, 2018. In the first video, we talked about how you know whether or not the property you're selling is in a common interest community. This video will talk about why that's an important, critically important piece of information for you to get as you begin the marketing process for seller's property. If the property is in a common interest community and it's the first time that the property is selling to a consumer, so in other words, it's a builder or a developer selling the property for the first time to a consumer, and the property is part of a common interest community, then the seller must deliver to the buyer a public offering statement. This is a document that the seller is going to have to put together. It's going to be a fairly thick and complicated piece of information. The builder will likely, or the seller will likely, have to call upon quite a few of their consultants to help them prepare the public offering statement, surveyors, engineers, construction consultants, lawyers, to help them assemble and compile the public offering statement, the purpose of which is to protect the consumer who's buying into a new community with a lot of questions that have not been answered by the mere operation of the community over the course of time. So the public offering statement is intended as a piece of consumer protection. For that reason, the consumer is entitled to 7 days to review the public offering statement. Now, I'm going to give you 2 rules associated with the review of the public offering statement, and I'm going to tell you right now, these rules I'm about to give you do not apply to the resale certificate, which we haven't even talked about yet, but there's a big distinction in the rules that apply to the public offering statement 7-day review period versus the resale certificate. So I'll make those distinctions again when we talk about the resale certificate, but with respect to the public offering statement only, 7-day review period, those 7 days may begin to run prior to mutual acceptance. So if, for example, listing broker gives a buyer a copy of the public offering statement at an open house, and then 5 days later, buyer enters a purchase and sale agreement to buy that property, then buyer would only have 2 days remaining after the date of mutual acceptance to terminate the purchase and sale agreement based on WUCIOA and the fact that the property is in a common interest community and the fact that buyer has this right to terminate based on receipt of the public offering statement. That 7 days is deemed by the legislature, though, as a critical review period, because at the end of the transaction, if buyer doesn't receive that public offering statement until right before closing, let's say they get it 2 days before closing, WUCIOA, the Washington law, says that buyer has the right, the statutory right, to extend the closing date so that buyer can take full advantage of the entire 7-day review period. And if buyer terminates during this 7 days following receipt of the public offering statement, buyer has the unfettered right to terminate the purchase and sale agreement, recover any earnest money they may have paid. That's the public offering statement, triggered only by the first time sale to a consumer. Once a property is sold to that first consumer in a common interest community, every subsequent sale will require delivery of a resale certificate. Now, if you've sold condominiums in Washington State, these terms, public offering statement and resale certificate, aren't new to you, but they are absolutely new to non-condominium residential properties. We've never had to deliver or resale certificates, especially with respect to the sale of houses in plat communities or other subdivisions. Now, if they're common interest communities, you would have to. A resale certificate. A resale certificate must be compiled by the homeowners association. Seller cannot create a resale certificate. Seller goes to the homeowners association orders a resale certificate, and the homeowners association is required to prepare and deliver that resale certificate to seller. Seller has to sign the resale certificate, which then gets delivered to the buyer. Once a resale certificate is delivered to the buyer, buyer has 5 days to terminate the transaction. Now here's the distinction between the public offering statement review period and the resale certificate review period. There's two very critical distinctions for you to understand. With respect to the resale certificate, that 5-day review period does not start to run before mutual acceptance. If seller delivers the resale certificate to buyer on Monday and buyer enters purchase and sale agreement with seller on Wednesday, buyer's 5-day review period begins on Wednesday. And when we get to the end of the transaction, if seller has not yet delivered the resale certificate to buyer until a couple of days before closing, buyer has no statutory right to extend the transaction closing date. Buyer can choose to terminate the agreement in those last 2 days prior to closing, but buyer cannot extend the closing date based on the late delivery of the resale certificate. A couple of things that I want you to remember with respect to both public offering statements and resale certificates. The buyer has no ability to waive the right to receive either document. If a buyer enters a purchase and sale agreement that says buyer waives the right to receive the public offering statement or buyer waives the right to receive the resale certificate, all that buyer and seller are really agreeing to is that seller may be led to believe that they don't have to deliver a public offering statement or a resale certificate, but as a matter of statutory law, they still are, in fact, required to deliver that public offering statement, and if they never and resale certificate, and if they never deliver the public offering statement or the resale certificate, all that really means in the transaction, the buyer's rights under WUCIOA, specific rights under WUCIOA, end at the closing date. So buyer has the right to terminate all the way up until the closing date if buyer has not timely received the public offering statement or the resale certificate, meaning they haven't had their full opportunity for the 7-day review period or the 5-day review period. Then worst case scenario for seller, they have the right to terminate all the way up to the closing date, but they have no rights under WUCIOA after the closing date. They might have a claim against seller after closing for some failure to make a required representation by seller, but their rights under the statute itself end at the closing date. And the final thing that is a commonality between both the resale certificate and the public offering statement is that the association, if you will, and with respect to the public offering statement, the association is typically housed firmly in the developer or the builder. The association, it must be able to prepare the public offering statement or the resale certificate as necessary in order to accommodate the requirements of the transaction. This may mean for homeowner associations that are common interest communities that there's going to have to be some level of professional management in order to enable sellers to know that they have a reliable resource in the form of their homeowners association to be able to capture the resale certificate in a timely manner. If you have questions on WUCIOA or common interest communities, send an email to me, legalhotline@warealtor.org. Thank you for being a member of the Washington Realtors.